Welcome to the Motor Carriers Insurance Education Foundation monthly truck stop. These webinars are presented for industry information, and they're presented on the second Thursday of each month at 2 p.m. Eastern Time. These webinars are presented again as industry updates for information purposes only and do not qualify for state CE credit and does not contain any legal advice involved in here. The lawyers we have are there to share information with us, and if you have any details or any questions, you may refer those directly to them. If you're seeking CE credit, we do have 12 hours of CE that we provide members on an annual basis. Contact our office, and Beth can help you work through those CEs. We're introducing somebody new here today, Joel Blitch. A lot of you all know about him because of his relationship with somebody that has been in front of you often, and that is Bridget Blitch, which is his wife. And Bridget is going to be with us at an annual conference in a couple of weeks, talking about the inspections. She's done something on the website with us talking about the data queues and the Food Safety Act. And in that case, she formed a new law firm a couple of months ago, and her husband became a partner with her. And I was sitting with them talking about it, and she says, he's an expert in employee practice liability. He gets in trucking a little bit here. So I asked Joel, and I said, Joel, that's a good subject, because I have felt often that employee practice liability is a coverage that is not often offered enough by retail agents, nor purchases enough from a viewpoint of an insured. In fact, I was quoted in a Transport Topic article some years ago, right after CSA came out, because I was seeing all these trying to discriminate concerning controlling who we have. In fact, if you remember, or you might not, but Bridget would be, some of the discussions when CSA came out that people were going to lose their jobs because of their MVR records and retaliations and hours of service. So I maybe made a comment when there was asked, what is the level of insurance that people traditionally don't buy? And in those cases, I mentioned employee practice liability, that I thought was an undersold product from a retail agent standpoint. I guess now maybe cyber liability are borderlines on those. But either way, David, Joel, welcome, and tell us a little about yourself, and then you will take off, and we'll have a little conversation as we go through this.
Yes, sir. Thank you. Again, my name is Joel Blitch. I've been practicing employment law, virtually only employment law, for the last 25 or so years. Makes me sound old when I say that. In fact, the other day, somebody mentioned I've been doing this for a quarter century, and I felt very old indeed. But I'm lucky enough to practice for my law partner and wife, Bridget, who's been deeply ensconced in transportation law for many years now, extremely knowledgeable, and also with Dick Westley, who's been practicing transportation law for about as long as I've been alive, which is quite a long time. We form what I think is a very wonderful team, and we're able to serve our clients in virtually every aspect of transportation law, from the cargo claims, the corporate restructuring, to the EPLI audits, to the other issues that transportation companies have to contend with, and of course, the employment law issues as well. So really excited about our new team. Our new firm is going gangbusters right now in terms of building its business and building its book and serving our clients. And we look forward to many, many years of success. But I wanted to touch on something that Tommy mentioned a minute ago, and about EPLI coverage. I mean, we onboard quite a few clients every week here, and some that have been around with me for many years, and some have been, and also some that have been around with Bridget for many years. Come to us and they ask us, about EPLI coverage and about whether or not we believe it's necessary. And my immediate answer, and I say this rather loudly and emphatically, is absolutely. You absolutely have to have EPLI coverage, so long as the policy has meets minimum thresholds and provides some minimum coverages, and doesn't have deductibles that are too incredibly high to make it cost prohibitive, EPLI coverage is essential. And why is that? Because the employment law is sort of the go-to these days in terms of the target that plaintiffs' attorneys seek to exploit. If it's and the Me Too movement has really sort of exacerbated this issue to the point where everybody and their grandmother is now claiming some form of discrimination, some form of harassment, some form of retaliation, perhaps a wage and hour claim. And so I hate to put it in these terms, but my phone is ringing off the hook with employment law claims that I'm having to defend, which is on a personal level great for me, but on for my clients not as good. And so if they don't have this EPLI coverage, then very, very quickly, if they're served with a lawsuit, they can, unfortunately, within a span of 6 months, be $50,000 in the hole in attorney fees. And that's a risk they could have avoided had they had appropriate EPLI coverage. So I wanted to go through some of the more important aspects of employment law, sort of from an overview standpoint. And then, of course, Tommy, if you want to jump in with questions, I know I talk fast, and I know sometimes I don't shut up. If you want to jump in with questions, please let me know.
Everybody on this audience knows that I'll do that, and I'm interested in letting them. I'm interested in this first part, letting him, because I have been taught through CIC and others and taught employee practice liability for a long time. And where I always starts where you're coming. What's the exposure, and how do you prevent a claim first, and make sure that you don't get hung up on paperwork and you respect the worker and you listen to the worker and handle those things. Everything from sexual harassment to age claims to ADA claims and things like that. And at that point in time, now you're ready to go by policy. So where we're starting today is that first part. The policies, as you know, varies all over the board, and we'll talk a little bit about that. But my focus is where are the exposures, and particularly as it deals to motor carriers, and how can we make sure that our onboarding paperwork when we hire a new driver doesn't violate some things. And obviously, as you know, Joel, they actually do violate some things, because there's things that are written into the safety regs and rules for CDL drivers that would be discriminatory in the areas of EPA or EOC and employee practice if it wasn't for safety purposes, like asking someone their age on the application. So that's where there's some balancing between the regular laws that you hear about, stuff you read on the radio or radio newspapers and the articles you have, versus hiring a CDL driver, which we do know something about the physicals and their age and all before we can give them a permanent job. So we need to balance through that. But go ahead, I'll let you deal from there, but we're on the same page.
Well, there is some interesting conflict between the EEO laws and the trucking laws. And Tommy, you hit the nail on the head in terms of the some of the age issues, some of the conditions that a driver can have and still operate as CMV. But I guess if you want to call it good news, if say a driver over the age of 70 isn't hired because of their age, that employer is going to be able to rely upon, because oftentimes the insurance policies will specifically prohibit coverage for a driver over the age of 70. The employer will be able to rely upon that. But there's a whole lot of middle ground beneath those bright line standards where employers need to be very careful. And the primary ones are the ones I list on this slide here, dealing with the overview and the protected classes. One of which is unlawful discrimination, which is an extremely broad topic, as well as unlawful harassment, which has a subset, the best known of which is sexual harassment. And of course, there are other types of harassment that can occur on the basis of other protected characteristics. But let's talk about discrimination and harassment in general terms. Well, not everything is unlawful discrimination. So Tommy, if I see you and I see that you're wearing a red shirt, and I don't want to hire you because you're wearing a red shirt, I think that your fashion sense is horrible. That's not unlawful. What is unlawful, however, is if I decide to make it an employment decision based upon your race, your sex, your religion, your age. Now, we spoke about age a minute ago, and the fact that oftentimes policies will exclude drivers that are 70 or over and will not provide coverage for them. But there's a pretty little known part about Florida law. And Florida law is unlike federal law. Federal law only covers those people who are 40 and over. Florida law covers people who are 18 and over. So if a motor carrier decides not to hire somebody because they think they are too young, or they're too baby faced, or whatever the case may be, Florida law provides for protection to that person, even though they're under 40. Florida law is much more expansive in the age realm than its federal counterpart.
Joe,
Also,
this is a point that I want to make here. Folks, you got to understand, Joel made a point here, that you have two layers of law. You have the federal law and you have the state law. And I've even had encountered, and I'm sure you have too, some county laws which have these things spelled out. Anytime you have a state law and a county law, those laws are more invasive than the federal law, because you wouldn't write that law unless you wanted to protect more people or have more regulation than the federal law. So you have those areas that not the federal you meet, but there's also some situations where you might have to meet a state, or in some situations even the county discrimination. And that is one that I've run into, where, like dealing in Florida, in Fort Myers with Florida, where it starts at 18, not the typical 40.
Right. And the other distinction, primary distinction at least, between Florida state law and federal law, is that Florida state law protects people from marital status discrimination. And heck, I've even seen this as an attorney. When I first got out of law school 25 years ago, one of the very first questions I was asked, I laughed because I was applying for an employment law position. They asked me if I was married, and I kind of looked at them, and I kind of looked at them like, what? But I answered him. I didn't blink. I answered him. But they didn't want somebody who was married and had kids. They want somebody they could make work 70 hours a week. And sure, I did that. But you'd be surprised the questions you hear. Even as a lawyer, the questions you hear.
Well, Joe, you make a good point. I do this stuff. You got to figure a way to get around that. What the question that I would say is, you start here and you work close here. Can you work 70 hours a week and have no problem with it? I did one for a restaurant one time and said that, you had to lift something 25 pounds over your head and maneuver between tables and chairs with no more space between. That's the essential function of the job. That's another way of saying you can't be old, fat, and weak, but you got to drill it to the terms, you follow what I'm saying, that fit into what you're trying to do, because of can you do it or not. But I also had one in this same restaurant that said you have to speak English or not, and they denied employment somebody that was hard of hearing or deaf. In fact, he said, I can do it. He read lips well enough that he was able to meet that requirement, even though he was deaf, and he became the more preferred waiter in that restaurant. So this is where, if you boil it down to what can they do versus looking at them and making that opinion without saying, can you do this? And I think that's a lesson that there's ways to word these things that don't discriminate and gets to the essential functions of what they've got to do.
Right. I mean, and that's why, one of the very big things I try to get each of my clients to do is to, number one, of course, have policies. Require policies under the law, like a sexual harassment policy, an EEO policy. But these things are easy. Everybody and their brother has a sexual harassment policy or an EEO policy, but not everybody and their brother actually follows the thing. And that's where the rubber hits the road, to use an industry term, and that's where we start to get into real trouble. I'm sure the Harvey Weinstein company had a sexual harassment policy, but we both see how much good that did, right? So along with having a policy, every single employer needs to train their supervisors and not just train their supervisors and nuts and the bolts about how to run a trucking company, the nuts and the bolts of how to be a supervisor, how to manage people, how to deal with complaints, how to deal with disciplinary issues, how to interview employees. I mean, just for sake of example, I had a client the other day, which I will not name, who came to me and they gave me their employment application for review. And the fourth question on the policy, or excuse me, the application was, "Are you a U.S. citizen?" And I thought, when I read that, my alarm bell started going off in my head, and my red pen came out, and I started circling and slashing and writing next to it. I mean, it's questions like that. And look, I know this client well. They didn't mean anything. They didn't mean to in asking that question to do anything insidious or wrong or evil. It's just that they don't understand what I understand. Right. And what I understand is you can't ask that question.
Again, you ask it, will you be eligible for employment?
The only appropriate question is, do you have a lawful right to work in the United States?
Yeah.
Period.
Anyway, but the beat goes on not only in the application, but also during the interview process. Do you know how many people have come to me over the years and they've been sued or they got charge of discrimination filed against them, and it's because they elected not to hire a certain individual, and they come to me and they say that, well, this is what happened during the interview. And I say, okay, well, great. Who was your witness during the interview? Because I want to talk to them too and get a statement from them. And they say, witness? What witness? Yeah. Like, you never interview anybody without another body in the room. Period. Plus, the other thing I suggest, you never view anybody without a written script. You don't want to go and mine a field and go fishing. You want a written script, and you want to ask those questions and those questions only. In fact, I even have some questions that early on, I don't know how you feel about that, and we got to move on because we could talk about this a lot of times, is I even worry about what you look for a resume. What can be on a resume and how to use a resume, because a lot of times the resume does say the things, are you married, kids, what church you go to, or what fraternities you're familiar with, and some of those things can lead to discrimination because now I know about it. I don't want to know about those things when I make a decision to hire somebody or not. And so this is the things that underline that change the paperwork.
Oh, let me point out one thing that I thought was funny, maybe my sense of humor has gotten a little weird over the years, but on that point, one of my clients came to me. They had been sued for marital status discrimination, and also pregnancy discrimination, gender discrimination, all three. And they said, look, we didn't do anything wrong. And so it was a failure to hire case. And so they send me over the resume and the application of the person who brought suit against them. And I'm going through it, and I'm trying to see if they're qualified for the job. And then down the bottom, it lists, personal interests, and it says, and it talks about what their young kids do and the activities their young kids are involved in. And the fact this woman was like a den mother for the Cub Scout troop. Well, the manager who was interviewing her wrote next to it, "No way."
and that becomes admissible in court. Yeah, that's great.
Yeah, you're right. You're dang right, it does. And so, trust me when I say that we try to resolve that case as quickly as possible before we had to disclose that resume in discovery. But anyway, I'm taking up too much time. I'm sorry. All right. So we talked about in general the protected classes. Now, and these protected classes aren't just in terms of discrimination, they're also in terms of harassment. Well, what is discrimination? At least unlawful discrimination. Unlawful discrimination is where you treat two employees differently based upon a protected characteristic, but only in terms of a term and condition of employment. So if you're dealing with a promotional decision, a hiring decision, a decision about whether or not to give a raise, a decision about whether or not to impose discipline, That is where discrimination becomes kind of a buzzword. So, for example, if you have two employees that have engaged in the same conduct, employee A, let's say, it doesn't matter what the conduct is. Employee A engages in the conduct. Employee A gets a written reprimand. Employee B engages in the same conduct and is terminated. That is where discrimination starts to grab a foothold. So if let's say employee A is Christian, employee B is Jewish, or whatever, pick a religion. One of the latter employee B, who received the more severe discipline, may be able to state a case that his religion played a deciding part, and the type of discipline that they were given, more serious discipline they were given. And it doesn't even matter, frankly, if the manager had no ill will in his heart towards Jewish people. What matters is that on paper, there's a difference. On paper, the employees engaged in the exact same conduct, but one of them received more significant discipline, and it just so happens this employee was with a different religion of employee A. And that circumstantial evidence is the building blocks of the discrimination claim. Even though there was no discrimination in the heart of the manager, perhaps there was, but let's say there wasn't, it doesn't matter, because by inference, a person can pick up on a discriminatory motive in order to establish that discrimination claim. So you don't have to prove that the manager is a bad person or they had discrimination in the heart. You only have to prove there's enough circumstantial evidence to suggest that was what was in the manager's heart, because nobody can know a person's soul, right? Nobody can know what's in a person's head. The only way unless they're going to admit it, which is never going to happen, the only way you can do it is through circumstantial evidence. So, and that brings me kind of to the next point I wanted to make. Just like you have to be very, very careful in how you interview and how you structure those interviews to make sure you have a witness present, discipline is also hugely important, because it is one of the bigger legal landmines in the employment law realm. Making sure discipline is uniform, making sure discipline is carried out well, making sure you have a witness present when discipline is given. Another aside, real quick. I had one case early on, and it stuck with me. It was probably 17, 18 years ago, where a woman had habitual attendance problems. And there are other employees who also had habitual attendance problems, but this particular woman was treated more harshly because of it. Well, the manager, sits her down, and he tells her he's made the decision to fire. And he decides to create a memo to the file about the decision. Now, creating a memo to a file about a disciplinary decision is a smart move, generally speaking. But in this case, the manager decided it would be a good idea to create a memo to a file, and I'm going to heavily paraphrase here. I'm going to make up a name. I'll call her Susie. I fired Susie today because she was habitually tardy and habitually absent, and he listed the dates in the last 3 months that she had been late or absent, which was great to this point, right? But then he writes, well, Susie just won't dump her alcoholic husband. He's a weight around her neck, and there's no salvaging her. Which, what does that do? Creates not only an associational disability issue, because alcoholism is a disability, but also creates a marital status problem. So it really is really stunning how badly people botch these employee decisions. But it just goes to show why training is so important.
Right. Everybody, here's where we're at in this minute. We've got slide one. We got some 30 slides, so we got to move on. It's the paperwork and the words and how you phrase things that get people in trouble. And so this is where you need to talk about your insured. The good old boy language just doesn't work today in this environment. And there's ways to achieve your end results of making someone working for you be able to do that job than taking shortcuts like we said, are you a U.S. citizen? There's ways around it. And so that's where you have to be careful. Words can kill you. Go ahead, Joel. Let's move on then.
Yeah, yes, sir. Okay. So now remember what I said, and this slide kind of demonstrates this. Don't let your good intentions and don't let your clients' good intentions lead them down a bad path. And a good one is when you have, you have a pregnant employee, and let's just say they're a female driver, and they become pregnant, and you know that there's a certain physical aspect of this job that's going to be difficult for sitting in one place for that long in a CMB. Maybe there's some loading or unloading responsibilities you think might be too arduous. You can't let your own paternalism get in the way of sound employment law practice. So in this slide, you have a recruiter refusing to hire a woman who's 3 months pregnant because he feels the work will be too difficult for her. Look, not a bad intention in their body, probably trying to look out for the best interest of the pregnant woman in their own mind, right? But good intentions have to go out the window. You have to treat everybody the same and not mention a word about the woman's pregnancy, not prohibit her from performing tasks unless she brings it up. If she now in this situation, let's say you had the female driver who was not just 3 months pregnant, she was seven months pregnant. You could ask her to show you how she could safely perform the job responsibilities, without reasonable accommodation. So let's assume that during the unloading process of the truck, there's some really heavy hose that the driver has to manipulate to offload the product. You could, without violating the law, ask that 7 months pregnant woman to demonstrate how she can do that safely, because you want to make sure that she's not going to hurt herself and that there's not going to be another sort of accident. So that's appropriate. But you have to be very careful. But I'll move on because I'm taking up a lot of time on these slides. Now, we need to talk about sexual harassment and other hostile work environment as well. Look, I mean, we all know what sexual harassment is. At least we should by this point. It includes crude jokes. It includes sexual overtures. It includes, of course. Oh, I'm sorry. My bad. Here I am talking and not where I'm supposed to be. Okay. Whoops. Sorry. There we go. There we go. Sorry about that. All right. So, inappropriate sex comments or jokes, obviously unwanted touching. These things are all open and obvious. But what's not open and obvious is that sex harassment is not just man versus woman or woman versus man. Sexual harassment can also be man versus man and woman versus woman. There was a pretty famous case in the Supreme Court many years ago where a man on an oil rig claimed sexual harassment by his male colleagues. And of course, the lower courts were kind of baffled by it, saying that, well, gosh, what are you talking about? It's man versus man. How can this be gender discrimination? How can this be sexual harassment? Supreme Court, rather resoundingly, on a 9-0 decision, found that, look, you can have sexual harassment from one man to another, and it need not be any homosexual overture. If a person is being picked on because they're deemed to be less manly, or they're deemed to be small or weak, or whatever the issue is, it's still sexual harassment.
And so they were calling them wimp and all that kind of stuff.
Right, and all sorts of other pejorative terms. Sexual harassment also includes, however, not just touching and not just repeated asks for dates or for sexual conduct. It also includes, and what this slide represents, making abusive comments about another gender. So let's say, for example, you have a female supervisor who calls her male subordinates stupid or idiots or cavemen or knuckle draggers, but doesn't call her female subordinates names like that. That's also sexual harassment. And the same goes for misogynistic comments that men make about women that they don't make about their male counterparts. So,
dumb blonde.
Dumb blonde, or women are good for one thing, or all men think about is one thing. The list goes on. we have to be aware of this, not just from a Me Too, standard sexual harassment perspective. It has to be more of a broader viewpoint. And I keep coming back to the training issue. Look, we can have policies of insurance all the live long day, but the best thing for our clients is to make sure that they never have to use those policies. They definitely need them, but the best way to prevent them from having to use them is to help ensure that they're training their employees adequately. Something this firm believes in very strongly, that we do very frequently, is we'll provide an employer a training program for their supervisors and sometimes for the rank and file employees. We'll go into their business with a PowerPoint presentation. We'll give an hour, maybe 2 hour long presentation to their supervisors. We oftentimes even give them a supervisory guidebook about how to be better supervisors. The goal being to prevent claims from ever occurring. And then from that point forward, the employer can probably carry on the training themselves on an annual basis. But it really makes a good impression. Let's assume we do the training and a claim occurs. It makes a tremendously good impression to a court and to a jury if we can tell that court and jury, look, we did everything we could. We trained our supervisors. We trained this supervisor. He sat for 2 hours in a room with our attorney and got training on what not to do, and he did it anyway. But we did the best we could. Now, will that limit? It will probably, if not eliminate punitive damages, which is obviously hugely important. And it can also hold a lot of sway with the jury in terms of how they view the employer. So good training serves so many purposes, including preventing preventing claims to begin with. Now, let's see here.
Are we on the next slide?
Yeah, let me just, I'm trying to move forward here. Unfortunately, I didn't number these. We've already covered all this. I'm just trying to get to, here we go. Now, hostile work environment and sexual harassment. Generally, and there's a highly legalistic definition of this, but it is generally a hostile work environment where the workplace is permeated with either sexism or racism or or ill will based upon religious beliefs. But oftentimes over the years, I've heard people say to me, "Look, this was a one-time event, and how can it be a hostile work environment if it was a one-time event?" I had one case in point where many years ago, where the CEO of a company told me there was a sexual harassment claim. He admitted that he grabbed one of his female employees in a very inappropriate manner. But he told me, "Look, it was just a one-time event. I mean, how can this be a hostile work environment?" Well, that CEO it didn't last very long after that. Once I told the president of the company what happened, but the more important part of that story is that you don't have to have a chronic, ongoing basis of conduct to create a hostile work environment claim. It can be a single incident if that single incident is sufficiently serious to create a hostile work environment. So, in that one occasion where he grabbed her inappropriately, it was such a violent, terrible, disgusting act that poor woman. I mean, her employment there from that point forward, for as long as that CEO remained in his position, was toxic. I mean, it's important to remember that we need to stop hostile work environment issues in their infancy, which goes back to the importance of a complaint procedure that we not only have, but we also enforce very strictly. And Tommy, what I want to run through just a real quick thing, and it's not on the slides, but I think it's hugely important. As I said, having a policy is great, but it doesn't matter. You can have a policy. It doesn't matter if you don't use it. So what we need to tell every one of our motor carrier clients and other trucking associated clients is that they need to train their supervisors on how to deal with a complaint of sexual harassment or any other form of sexual harassment when it comes to them. Because if we deal with it appropriately, then it may never become a claim. And that's that's what we're here for, right? Where we want to, our job is risk mitigation to prevent these claims from ever occurring. So when it comes to a supervisor to complain about sexual harassment, that supervisor, just a couple points, supervisor needs to deal with that issue right then. Not after breakfast, not after lunch, not 3 days later, right then. They need to bring somebody else into the room to hear this person's concerns. If the claim is against the supervisor that's hearing the complaint, he or she needs to pull himself out of the room and bring in human resources or somebody else in authority to hear the complaint and divest himself of any responsibility for it. But in any event, the employee's concerns need to be heard. They need to be thoughtfully considered, and they should not be dismissed. I mean, one of the biggest issues I've had over the years is that somebody comes to a supervisor to complain about sexual harassment, and supervisor will try to say, well, no, Bob didn't mean anything by that. Bob's just Bob. You have to understand Bob. Bob's harmless. Well, that's the absolute wrong thing to say. You never try to explain away the conduct and dismiss it, because what does that do? It only creates ill will. It only creates what could be a future playground for more sexual harassment because you haven't done anything about it. And it only leads that employee who doesn't feel valued and hasn't been validated potentially go outside of the employer to an attorney to vindicate their rights. So you have to treat that complaint as being extremely serious. Don't dismiss it, and make sure that's properly investigated. Which means generally in the large organizations, you kick it off to human resources and let them do their jobs. But I could go on and on about how to handle a sexual harassment claim. But Tommy, if you want to chat about that, we can. But I'll keep going because I know we have a lot of time.
We need to move on. Right.
Okay.
Yeah.
All right. Okay. Now, let's see. Okay. The next slide talks about the factors that can take into consideration in defining what a hospital work environment is. I don't think that has much value. We've already gone through it, right? Now,
same thing here. That's the words, and this cuts. I mean, the bottom line, you got to watch your words. And the thing that you just said that I always bring out, you got to take every case seriously, no matter how that. You cannot ever excuse that, and you need to have someone investigate it who's not in the employment relationship. They don't make relationship decisions. This is where you got to. I agree with you. The good old boy mentality in trucking businesses, they sometimes slough those off, and that's very important here. Just like you hear off-color stories. I mean, how many jokes in a locker room? You got the cases here where pictures might be offensive and these kind of things. So these are things that you just need to be aware of those things, Joel. That's what we need to go. Go ahead.
Right. And look, I know it's impossible to create a workplace that's completely free of any type of sexual innuendo or other inappropriate conduct. I mean, it's impossible. It'll never happen. It should be our goal to try to create a workplace that is as free as possible from these folks. It means the supervisors act professionally at all times and not be part of the good old boy system. They need to set the example. And that's why supervisory training becomes more and more crucial. Now,
okay, go ahead.
I'm moving. Okay. All right. Okay, let's go to this. All right. How do you build an effective sexual harassment or anti-harassment EEO policy? Number one, obviously it needs to be in writing. Number two, you certainly should have qualified counsel review it. But number three, every single employee, every driver, everyone needs to sign off in writing that they received the policy, and that they understand the policy. And if they have any questions, they know who to go to ask questions about the policy. So that acknowledgement that they sign needs to specifically state that they fail to abide by it. It can result in disciplinary action up to including termination of employment. Now, what I almost always recommend to my clients is that their sexual harassment policy more than forbid sexual harassment. It also needs to instill upon every employee the responsibility to report sexual harassment, not just supervisors. Every employee, if they observe something, they need to see something. So in other words, if your employee observes some sort of inappropriate sexual conduct or perhaps some sort of racial epithet used in the workplace, and we learn of it 2 or 3 months down the line after the employee complains, and we learn it through witness testimony or perhaps from the employee themselves that they observed it, they didn't say anything, that policy needs to specifically state that we may take disciplinary action against them for not saying something. That also extends to the victim. Every single person, including the victim, has to have a responsibility to report it, because unless they come forward, what happens? The situation becomes typically more serious, typically more grave, and typically something that could lead to a claim. And it is not retaliation to discipline the victim of sexual harassment for not reporting sexual harassment. So,
guys,
Tommy?
Yeah, go ahead.
Okay, so having somebody review your client's sexual harassment policy is really important. So all those elements are there. Now, one thing we haven't touched on, and we really need to, and it's in the slides here, is retaliation. Retaliation is kind of the favored son of employment law right now. In my experience over the last 3 or 4 years, more retaliation claims have been filed versus any other type of employment law claim, except for maybe FLSA claims. Long story short, retaliation is if somebody engages in protected activity and they suffer some sort of employment detriment because of it. So if they complain about sexual harassment, complain about racial harassment internally, if they file a charge of discrimination, if they tell somebody to stop harassing them, to stop discriminating against them, all these different things are protected acts under the statute. And if that employee suffers any tangible employment detriment because of that complaint or that protected activity, such as demotion or failure to promote or, God forbid, termination, these things can lead to very significant employment law claims. So everyone needs to be reminded that if somebody brings some sort of employment law complaint, internally or externally, that it doesn't mean that they're bulletproof. It doesn't mean that they're made of Teflon. It doesn't mean you can't fire them for any reason. It just means that you need to be much more careful and how you deal with that employee from that point forward, so that we can mitigate the risk that an employer will later claim that they're being demoted because of their protected activity or disciplined because of their protected activity. And you need to have a policy in each handbook that goes along with your anti-harassment and EEO policy, which forbids discrimination on the basis, retaliation on the basis of any protected act. Again, policy writing is hugely important, and the training to go with it is essential. And without those two things working in tandem, then it's our job to watch our employees' backs and help mitigate it. Okay, and now we're on. Tommy, did you want to chime in about the EPLI and EPI?
Well,
EPL
for
coverage?
sake of time, Bridget already, you introduction part of this, as we talked about it. Employee practice liability, folks, you need it. You need to make sure, and there's a price thing, as Joel said earlier. The deductibles, you got to cover the basic harassment, sexual harassment, retaliation, discrimination. Those are the three basic coverages. You can get third party, you can get others. In trucking, you at least need the basics covered involved in this area. And one of the things that you're going to find is that a lot of these cases only come when there is termination. When I used to teach this, my comment is, when do you have the most exposure? It's when the company is no longer feeding that employee. So they come out and try to find out somebody here. This is why it's important to have the coverage and also to react to it quickly. And then the most of the employee practice liability coverages now will give you some assistance. A lot of them have referrals to lawyers to help you write these things. They'll give you suggestions on how to word these contracts and all that. So, Joel, my suggestion is there's a lot in the marketplace. You want to look at more than just price. You want to make sure you cover the basics. You want to have it within a deductible you can afford, and you want to look at the deductibles again without doing. Some deductibles are waived if you're insured did nothing wrong. Some are not. So it's just more than we can get in right now comparing coverages other than they need it. And you need to go to some of the markets and look at as you sell this to your insureds, look at the market you have and be able to explain to your insureds what that policy does and be aware of, are we covering all the areas of discrimination, including third party? Can they afford a deductible? And explain to them how the policy works. And also, if you have ability to have them deal with a risk manager or a lawyer to help them set these things up, or 800 number in case something comes in, that's also a very strong advantage. In other words, sell more than the piece of paper, sell what it does when it happens, and use this information that Joel has so far that we'll end up finishing here yet today to show them where they could be vulnerable.
Right. Now, the crazy thing I've seen in terms of some of my clients at least, is that they'll buy EPLI coverage without even having seen the policy. And they'll come to me after a claim's arisen, and they'll show me their policy, and sometimes it'll turn out that what they bought is not what they really thought they bought. I always try to make sure my clients understand what they're getting into before they buy an EPLI policy, and they share it with their counsel, just so that they have a complete understanding of what they're getting into before they purchase the policy. So we want to make sure that those expectations are realized.
Yeah, and there's a lot of traps in this employee practice, guys. You listen here, if you're not familiar with it, a lot of it's on a claims made basis. A lot of it you have to report it, and you have a tail coverages and things like that. It's more complicated we have here. But agents, you need to look for a good product and make sure that you sell something you'd be proud of that doesn't give you exposures. And part of it is looking at insurance activities and how they are managing those activities and these things here. But Joel, I agree with you that price is not the only way you look at this. You got to look at what the policy is going to do in protecting the insured. And as you just pointed out or alluded to, there's no standard coverage like ISO, auto liability, and general liability that I quote every day.
Right. And Labor Standards Act, which is kind of not really dealing with the EEO topics, is kind of a side issue. Wage and hour claims are, as you know, Tommy, extremely common these days, and it's probably that law happens to be one of the most easy to violate because it's complicated, it's burdensome, and it contains many different traps for the unwary, such as the independent contractor versus employee issue, all the different means by which an employer can violate the Standards Act. I generally try to encourage my clients to purchase a bill as long as the price is not outrageous. So that's another thing I would like to consider with this thing.
Joel, your headpiece is coming in and out.
Is better?
Yes. Go ahead. Yeah,
okay,
we did go on, Joel. We'll talk about the coverage.
Okay, very well. Tommy, do you want to talk about director and officer coverage?
No, a lot of EPL is covered in directors and officers, but you have to be careful about that, who it extends to beyond that. Some of the policies cover that, but most of these small motor carriers, they don't think they have that exposure, but they could, depending on who sets up the regs and the rules. But that's also, most of the people who are listening to us who do this realize you can buy EPL as a function of D&O as well as, or standalone. Right now, I think we want to focus on the standalone coverage. I think that's more applicable to the type of motor carriers that most of these people you're dealing with. The one thing that go ahead here, and okay, yeah, let's don't go through the insurance part of it.
Okay. So, damages under an EPI seemingly cover the full gamut, given this definition.
Joe, your headset's not working.
All right, let me step off of it. Give me a second. Is this better?
Yes, go ahead.
Okay, I apologize. Okay, so we're dealing with this slide about EPLI damages. And as you can see, it seemingly is pretty broad, covering any award or settlement, front pay, back pay, emotional distress, or attorney's fees. But it can also contain some pretty significant exclusions that clients need to be aware of. And those are demonstrated here on this page. Now, certainly, it's not going to include anything that deals with the cost of reinstatement of an employee if the court orders it. It's not going to deal with payment of insurance or disability or pension or health benefits or anything else explained on this page. Tommy, do you want to offer anything about the damages issue?
No, I don't, for sake of time, the focus I want to hear is let them know what the exposure is and also to do it. These are insurance people that listen to this, and they should be able to look at all these things in the policies, and we can come back and revisit the actual wording of the policy later on this part.
All right, that's fine. Then let's talk about the damages that can result from a successful employment law claim. Title VII.
You need to go to, you got a slide you want to go to?
Actually, I don't. I'm sorry.
Okay.
I don't have a slide. But under Title VII, the damages that are available are similar to those under state law. But under Title VII, the damages are capped according to the size of the employer. Employer with 50 or fewer employees has a certain damage cap applicable to it. An employer with 100 or more employees has a different damage cap. But in the Florida law is different in that it doesn't necessarily contain much in the way of damage caps. But the damages are available. Our first compensatory damages in dealing with any sort of emotional distress, any sort of exacerbation of a physical condition caused by emotional distress. It, of course, deals with back pay, attorney's fees, and also offers the availability of punitive damages. The employer's conduct was deemed to be malicious or in reckless indifference to the federal or state law. Now, what's interesting about the emotional distress damages is that it's not just dealing with sleeplessness, or not just dealing with loss of weight or anxiety, the typical harbingers of emotional distress. It can also relate to the exacerbation of underlying physical condition due to the emotional distress. There's a case I handled several years ago where a nurse had MS, and her employer made some very significant sexual overtures to one of her supervisors, and did it on a chronic basis. She complained to her employer repeatedly about the sexual harassment, but did nothing to try to mitigate it. And as a result, the employee's MS grew more serious and went from being almost a mild case, if there is such a thing as MS, but became much more serious and much more debilitating. And in that case, she claimed that the exacerbation of her MS was caused by the emotional distress that her employer put her through and not dealing with sexual harassment. And that argument was one that resulted in significant liability. So it's something that we all need to be cognizant of, and we need to be cognizant of in reviewing these policies to make sure they provide adequate coverage to our clients.
Joe, let me ask you a couple of questions.
Sure.
You just mentioned, and that's the threshold of damages. How many employees you got? 50 and 100 and all that. But the insurance still responsible for back pay and these kind of things? Those damages are over above the actual cost to make restitution to back pay and all of it. Is that not right? Are those also capped? I know emotional trauma and all those, but not loss of wages and those. I find that in a lot of cases those aren't capped, are they? And also that, as you just mentioned, in Florida, even though the federal is 50, Florida is any employee, any employment.
Right. Under Title VII, the damages for back pay are not. The damages for emotional distress are, according to the size of the employer. Even punitive damages can be capped under Florida law. But the attorney's fees aren't capped. Right. Honestly, the attorney's fees in these cases can be perhaps more dangerous than anything else. If you have a case that goes to trial and then potentially to appeal, the attorney's fees can be $150,000 to $200,000, not just for the insured, but for the plaintiff. And the plaintiff successful in the litigation, they can recover every dollar of that attorney's fees.
Yeah, if you've got to realize what you just said, and this is the hammer that you have here. If the plaintiffs receive $1 compensation, then you're responsible for 100% of their attorney fees. This is where it's tough at the end to make a settlement. This is where if you don't get involved in it quickly. I was in a day-long mediation one time, Joel, where in the first 30 minutes, we knew what we were going to pay the person. It took us the rest of the time to figure out what we're going to pay their attorney in trying to settle that stuff. But this is what's here. But in recap, the problem we have that who is subject to being potential in this area is also people who have a lot of turnover, and truckers have a lot of turnover because of the movement of the movement of employees, and that's when they might see they don't get paid, they want to get paid back. I find, Joel, this is when they seek these kind of reasons to do this kind of stuff. And I think the point you made earlier here is that you have to be careful how you say things, and you got to have the supervisor understand that. And the thing that I have found that you alluded to very strongly here is you got to take these cases seriously. You got to get away from the good old boys. Every complaint by an employee is serious to that employee. And if you nip it in the bud and take care of it now and address it now, typically that will keep it from boiling up and becoming worse later.
Oh, yeah. I mean, we all know the term preventive maintenance, right? Well, it's not just applicable to the truck. It's available to the employment. It's also applicable to the employment relationship. If you don't do the preventive maintenance to protect these claims, you're just asking for that engine to throw a rod and for you to have a big bill at the end. I'm not sure I can put it any better than that. So policies,
guys,
train, enforce.
Agents out here, hopefully we went through this and we got off the slides, which I don't apologize for because I think Joel has given us a lot of information. I'm relying on y'all to check out your insurance coverage and all, but I hope what you got out of this hour with us is that every motor carrier needs employee practice liability, and this needs to be put within the framework, not only ones with more than 50 employees, even some of the smaller ones, because they say the Title VII is applicable for smaller risk, and states can do that kind of stuff in the areas. And the only thing that's capped in larger ones is the penalties that might be, but you still could be responsible for back wages and retraining and those kind of things. Joel, you want to say something real quick as we close this out?
I think I've run on enough. I apologize for that, and I apologize for going off the slides.
No problem with that. We'll usually, this is the first time out. Guys, these are the firm. Again, you'll meet, see Bridget again at the annual conference who are coming here, and she and I are working on another program right now to share with you in a couple months. Joel, thank you, and thank Bridget for doing this. And with that done, this is the truck stop for this month.
Thank you. Good day.